Friends, let us dive into another case law, leading case law, which is in the syllabus of Advocate on Record examination of the Supreme Court of India. Friends, today's topic is, you can say case law is TMA Pi Foundation versus State of Karnataka 2002. Dear friend, this case deals with the right of minorities to establish and administer educational institutions under the framework of articles of Constitution of India, that are Article 91G, Article 26 and Article 30, Subclause 1. Honorable Supreme Court held that while minority institutions have the right to establish and manage educational institutions, but this right is not absolute and is subject to reasonable state regulations, especially when public funding is involved. Friends, there are two types minority institutions. One is aided one and second one is without any aid from the government. So, in this case, the key points which were decided were, firstly, how the Article 30, Subclause 1 gives them rights. The court affirmed that minority, although it is religious or linguistic, have the right to establish and administer educational institutions of their choice. However, this right must be balanced with national interests, and the government can impose regulations to ensure educational standards and to prevent malpractices. Second one was how much state regulation and in what way can be had. The court held that the state can regulate administration policies, fees, and recruitment in educational institutions. For aided institutions, the state can impose regulations to ensure quality. But such regulations should not undermine the minority character of the institution. For unaided minority institutions, state intervention is minimal and institutions have greater autonomy, particularly in terms of admission, policies, and fees. Now, third point decided was what should be the admission policy. The court said minority institution can admit students of their choice, but the selection process must be fair and transparent. The court emphasized that these institutions must not ignore merit in admissions as it would affect the quality of education. Then there was discussion of fee structure and there were orders for the same. Institutions, particularly unaided ones, have their autonomy to determine their fee structure, though the fee should not include capitation fees or excessive charges. The court also highlighted that institutions should not profit from the fees charged. Now, next one was minority status, how it to be decided. It said that court clarified that determination of whether an institute is minority institution depends on the state in which it is located. And the minority status should not be used to bypass national regulations that are in the interest of larger public. So I am concluding this topic. The court recognized the importance of preserving the rights of the minority educational institutions to manage their affairs while ensuring that education system remains equitable and of high quality. It balanced the autonomy of these institutions with the need for regulatory oversight to prevent exploitation and to ensure fairness in admissions and fee structures. That was all about this topic. I will go on diving into these left out case laws one by one for the time being. I say, have a nice day. Best of luck.